there has to be some common sense.
Yes, sir. They have the car stopped at 10th and Ranch Michael Byler.
We still don't know who pulled the trigger.
Hello, everyone, and welcome to Police Off the Cuff, Real Crime Stories. I'm your host, retired NYPD Sergeant Bill Cannon, 27-year veteran of the NYPD. You know, folks, a lot of things happening in the Idaho case, of course, with Brian Kohberger and the victims, Ethan Chapin, Zaina Knodel, Madison Mogan, and Kaylee Gonzalez. We always want to name them by name and just not call this the Idaho quadruple, because they are real people, and we don't ever want to forget that this case is about them. There's the names up on the screen. Idaho strong, we'll always remember that. So a lot of things happening in this case, a lot of motions being filed. They didn't get to everything yesterday, and a lot of the motions being instituted by the defense have to do with things that they seem to me, my experience as a 27-year police officer and a investigative boss for 16 years in the detective bureau, some of them seem like a stretch to me. You know, what do I mean by a stretch? Well, asking for the training records of some of the investigators involved in this case, to me, that seems a bit nitpicky. And look, the defense can request anything, whether they receive it or not. That if the prosecution hedges on giving it to them, then the judge will make a decision on whether or not that should be considered discovery material. The other thing is that, you know, other motions were the training records. The grand jury, challenging the grand jury indictments. I think I've never really, in my police career, seen any defense attorney challenge the grand jury, because that basically is the indictment. And a grand jury indictment, as people say in New York, you can indict a ham sandwich. It's not that difficult to obtain. You know, the grand jury determines whether there's enough to go forward to proceed, and they vote. And if they vote yes, it comes down in what's known as a true bill. And the true bill is the indictment. And we spoke about this numerous times also, is that the grand jury proceedings are secret. Many people following this case in the true crime world, they just don't understand that. And they think that the prosecution is trying to hide something. One of the many reasons that a grand jury is kept secret is to protect the identity of witnesses. Look, in many cases, a grand jury witness, his or her life could be in danger based on testifying against a defendant. All the time in big cities, inner cities, people, you know, it's the old expression, snitches get stitches. There's a lot of truth to that. Therefore, grand jury minutes and grand jury, even the fact that there is a grand jury, can be kept secretive. It's nothing that the prosecution is hiding. It's nothing untoward, and there's no corruption involved in it. It is a strategic move in this case that the prosecution used the grand jury system and not the hearings they were supposed to have. I believe that were already, they were scheduled for June 26th. That date is already passed. So it's again, nothing secretive, but there's a lot of people with watching this case, following this case, with lots of opinions and lots of, as a fact, incorrect opinions. So yesterday, of course, Brian Kohberger was in court in Moscow, and as lawyers, one of the big things they have to do is launch a fight against the prosecution's intent to seek the death penalty. Yesterday in Latah County Court, the judge's name is John Judge. What an appropriate name for a judge. I don't think you could come up with a better name than that. So several motions were filed yesterday by the defense, including seeking details about the DNA evidence, seeking details about the grand jury, which returned a murder indictment against him, and issuing a stay on proceedings to put a pause on the case heading to trial. You may ask, why does the defense want to put a stay on this? And just last week, they was pushing it to go to trial right away. Clearly, the defense is not ready to go to trial. And a lot of folks have also been arguing about, well, why has the prosecution not released everything to the defense? Well, I'll tell you why. Because strategically, they do not have to. It says all discovery material, this is an Idaho law, criminal procedure law. The discovery material must be given to the defense prior to the start of the trial. The date of the trial that the trial is supposed to start is October 2nd. So would it be uncommon for the prosecution to give the bulk of the discovery material on October 1st? Probably not. The defense is not going to like that. Can they do that and be in compliance with the criminal procedure law? 100%, yes, they could. So it's their strategic technique of what they're going to do, when they're going to release the discovery material. And they're perfectly within the law to withhold certain evidentiary material until the beginning or the start of the trial, that date. In a key motion to compel, the defense argued that the prosecution should hand over all information about the genetic genealogy and DNA evidence, which ties Mr. Kohberger to the murders of the four slain students, Kaylee Gonzalez, Madison Mogan, Ethan Chapin, and Zaina Knodel. According to the defense, this includes information about the scientists who carried out the DNA testing orders and what led authorities to him in the first place. Mr. Kohberger's attorneys, of course, Ann Taylor being the lead attorney, said that they're not on what they commonly use the term in a court of law, a fishing expedition, when they're really searching for things because they don't have any better defense. And I'm not saying they're on a fishing expedition, but they use that language. The defense used that language to say we're not on a fishing expedition. I spoke about this earlier. Among some of the evidence that they requested were the training records of three of the investigators who interviewed what they determined to be critical witnesses. They also want information about the FBI team that led the criminal probe and the background on the tip that led to the search for Mr. Kohberger's white Hyundai and cell phone records cited in the probable cause affidavit. So all of that stuff, the defense wants turned over to them. Again, there's a heightened standard right now because the prosecution has released their intention of going for the death penalty. So does that knock this case up a few more notches? One thing it could do, a possibility it could do, is, and this was last night, I spoke about this with Professor Mike Geary, retired NYPD Sergeant Professor, law degree Mike Geary. He said what the prosecution could be trying to do is to get Brian Kohberger to take a guilty plea. And you may ask, well, how is that a possibility? Well, once the defense learns of the totality of all the evidence they have in this case, there's a good potential a possibility. I'm not saying that actually I don't know what's in the mind of William Thompson, but they have that as a bargaining chip. Guess what? We'll take the death penalty off the table if you plead guilty. And once the defense sees what they're up against, there's a potential that they could convince their client. And I'm not saying they're going to, I just say there's a potential that they could convince their client that, something, they got a pretty damn good case. And we don't know if we can, beat this in court. We think you should consider, or you might consider, taking a guilty plea. And again, this is just conjecture right now, but that is a possibility that they can use this leverage of the death penalty to get Bryan Kohberger to take a guilty plea. The defense wants all kinds of evidentiary material, including how the FBI, and the DNA, the whole DNA thing is complicated, because you may ask, or many people may ask, what was it that led the prosecution? What was it that led law enforcement to have enough probable cause to get an arrest warrant for Bryan Kohberger? Did they need the DNA that was retrieved out of the garbage pail behind their house that was identified as Bryan Kohberger's father's DNA? Or did they have probable cause earlier based on the fact that the Hyundai Elantra, which was caught on video and which allegedly a witness gave them a tip that it belonged to Bryan Kohberger? Or was it a lot of things? Was it more than one thing that led them to probable cause? I would imagine it was more than one thing that gave them probable cause. And now they have the DNA of the father, which, boom, they get the arrest warrant. They go to Pennsylvania. They do a buccal swab on Bryan Kohberger's cheek. That is compared directly against the touch DNA on the knife sheath. And we all heard the number. It was 50-something 1 or 57 with 27 zeros after it, that it belonged to Bryan Kohberger. So it excluded basically everyone else on this earth except Bryan Kohberger. So that is a huge piece of evidence for the prosecution. It's a huge piece of evidence that the defense is going to have to come up with some doubt on that piece of evidence. How are we going to create doubt on this piece of evidence? What about this piece of evidence can we create doubt about? That it was found next to the body, or underneath the body, or underneath the blanket of Madison Mogen? Was there blood on the knife sheath? We don't know that. If there was, the prosecution didn't release that. So all of these are questions that, the defense wants to know the answer to, and so much, again, of the evidence has yet to be released. So again, many people, the broadcast media, many people, content creators, they're really questioning, they don't have anything against Bryan Kohberger. Well, I think they have a lot of evidence against him. Much of it, or probably 80 to 90% of it, has yet to be released. So that is what's keeping the public on the edge of their seat, saying, they got nothing in this case. There's nothing against him. The defense is going to beat this case. I mean, I don't think that's going to be the case. The prosecution argued yesterday that most of the materials that the defense was seeking has been released to them. But there's lots of evidence that the defense does not know about. So how can they ask questions about what they don't know about? The other thing in regards to the DNA, and all of us, I don't think that the only people that are experts in investigative genetic genealogy are the folks that do it, that are the investigators in the investigative genetic genealogy. Because not only is there a DNA component, but there's a large computer component to it, a large component of searching and eliminating people. So the type of DNA they use to compare in law enforcement, to compare against the CODIS database, which is run by the FBI, which stands for the Combined DNA Index System. And that is DNA collected from convicted offenders they don't have a choice. Their DNA is taken from them and it goes into the FBI database. Now, the test they do to compare against the CODIS database is something called STR, which stands for short tandem repeats. Now, those short tandem repeats has what C.C. Moore, who is probably the foremost expert on investigative genetic genealogy, it has about 20 different markers as compared to the SNP test, which is used in investigative genetic genealogy. The SNP test, and here's a tongue twister, it stands for single nucleotide polymorphism. And the SNP test has over 1 million markers. So there's many moving parts to that, because it has to be compared against genetic databases. And there's at least 3 that law enforcement is excluded from using. And I'll name those. Ancestry.com, law enforcement is not allowed to use that database. 23andMe and MyHeritage. All of those 3 databases exclude law enforcement from using. So you may ask, well, what is law enforcement allowed to use? And they're allowed to use 2 databases that are much smaller than those 3 that I just named. One is called GED Match, GEDmatch they call it, and the other one is called Family Tree DNA. This research, or this information, I got right out of the mouth of C.C. Moore, because these are areas that, of course, the legal profession wants to argue that how do we know that the DNA that this was compared against was obtained legally, and that the person's DNA that was in there agreed to allow it. So again, the 3 databases that the most common, the largest, the ones with the most DNA profiles in is Ancestry, 23andMe, and MyHeritage. Strictly, law enforcement is not allowed to use those. So what do they have to do after they do get a match? First of all, one of the things that we'd like to everyone to know is that a investigative genetic genealogical hit, what they would call, or they actually use the term match, even though that's not the most accurate term to use. They use the term match. So when the defense asks for the FBI family tree work, it can actually reach up to 1,000 people. So that the problem with that is, are the records kept of all 1,000 of those people that built the family tree? That's a question that perhaps the investigators, you have to keep good records in law enforcement, obviously. Every time an investigator talks to a witness, talks to a defendant, talks to anyone, it's supposed to be memorialized, and each police department has its own jargon as to what they call an investigative report. On the NYPD, it was called a DD5. And for short, they'd call it a 5. Give me the 5. So every time an investigator would interview a witness, a perpetrator, or anyone, or noting his observations, his or her, depending on the sex of the investigator, that must be memorialized on an investigative paperwork, or in NYPD jargon, a DD5. It is a favorite expression of all the bosses and everyone on the police department. If it's not on a DD5, it wasn't done. So detectives have heard that a million times, and they know whenever they speak to someone or whenever they perform any investigative function, it must be memorialized in writing as in the NYPD on a DD5. So all of this is good information to know for the for the true crime, for the real crime person that watches this and say, oh, how do they memorialize this stuff? How do they know it's accurate? Well, when you read a case folder on the NYPD or the FBI or any investigative body, it should read like the story of the case. And it has to be indexed and followed. And it should be in some chronological order that makes sense so that the reader can understand what's going on. It should be an index on the left side of all the DD5s, of all the documents that are in the case folder. So that's how the professionalism of law enforcement. Could you imagine law enforcement wasn't required to write things down and people depended on their memories to remember things? There's no way. There's no way. You must, and that's the sign, the mark of professionalism is good writing and good investigative case folders and memorializing investigative interviews, investigative things that the investigator does to be memorialized in a case folder. I'm going to play a little bit of Dan Abrams and yesterday as they commented on the hearings in this case. Brian Enton is on here. And
joining me now, Jesse Weber, attorney and host on Law and Crime Network, which I founded, and News Nation senior national correspondent Brian Enton. Thank you both for being here. Appreciate it. All right, so Jesse, let's start with you. What do you think that we learned today or are learning from the defense about what could be telling in their strategy moving forward?
Yeah, they're putting a microscope on investigators here, and I believe they're doing it for two reasons. One, their goal is to get any of this bad evidence out of that trial. They don't want the jury to see it. So did investigators do something improper in the collection of the evidence? If they can get this evidence thrown out, that's their main goal. If they can't, I think they're previewing a strategy.
Folks, last night, Phil mentioned something, and it's so true. And there's something called the fruits of the poisonous tree. And basically what that is that evidence that is not collected, invoiced, properly handled, can potentially be excluded by the judge. And so all of that is also the mark of professionalism by a good investigator and by the police, that they legally obtain, legally invoice, legally process, and have the chain of custody correct so that the evidence is seen as legally obtained and, of course, collected in the proper manner. And if it's not, if there's any of those things that are incorrect, a judge may exclude the evidence, and that's known in law enforcement, in the legal profession, as fruits of the poisonous tree, meaning that potentially the evidence was collected improperly or illegally. And that's the judge's call.
A trial saying there was a rush to find this killer. There might have been missteps taken by police officers. They didn't look at other suspects when there was evidence pointing towards other suspects. And that's how I think they want the training records for 3 police officers to say, is this how you're supposed to ask questions? Is this how you're supposed to follow up leads? It was a short hearing, but I think it kind of gave us a preview of where the defense might be going.
And Brian, we learned that he'd been arrested before, Brian Kohberger. What was that for and how significant is it?
Yeah, this is interesting coming out of Pennsylvania where he lived. There was an arrest back in 2014. He was arrested. His father actually had him arrested for stealing his sister's cell phone. Apparently, this is when he was dealing with drug addiction at the time. The dad was trying to get him help. It could be interesting moving forward, though, the fact that, again, the dad was involved and had him arrested might go back to a defense strategy that if the dad thought something was strange about Kohberger in this instance, would he have gone forward and reported?
Do you think that's going to come in at all in this case?
I only see it coming in one of two ways. If he were to take the stand
Yeah.
and they need a prior, record or arrest, or during a penalty phase, if it's during the death penalty phase and they talk about his past. Other than that, I feel is very irrelevant. But for us, it's interesting because we learned something about his past.
All right, so Brian, we've got new video now of.
It's a little bit remarkable to me that it's taken till June 27th. The arrest was December 30th. For us to find out that Brian Kohberger had taken a collar, had a previous arrest. I never knew this. It's the first I'm hearing of it, actually. Actually, Phil told me about it yesterday. Phil Grimaldi, my co-host. So why did it take this long? Isn't that the first thing they would do is run his criminal history to see? Because I would ask also, was this charge? I would think stealing a cell phone is a felony, because it has the felony grand larceny because there's the potential. Look, most cell phones these days cost over $1,000. That's the money threshold for in New York State for grand larceny 4th degree, unless it was pled down to a misdemeanor. And if you're convicted of a felony, potentially you could be in CODIS. You could have your DNA taken. So this is the first time I'm hearing this, and I wonder why it took so long for us to hear about this.
The preparations for the demolishing of the home. Talk to us about it.
Yeah, this has been ongoing for a while. They keep saying the house is going to get demolished, and then it just doesn't happen. Today, all of a sudden, this big truck showed up. You see it there. They sealed off the entrance to the house, so you couldn't see what they were bringing in and out. But we're told it was more personal items that belong to the victims. They're going to return those items to the family. We're also told by the university, which now owns the house, that it has officially been cleared by the court, so it will likely be demolished. They're not giving an exact time frame. 3 of the 4 families, though, don't want it demolished. They want it to stay in case there's a trial and the jury wants to.
Well, I was just going to say this means there won't be a jury visit, which is not, which is rare, but it does happen on occasion.
Yeah, I mean, in most recent memory, we think about the Marjorie Stoneman Douglas High School shooting. The jury went to see that and had
Alex Murdaugh.
Or Alec Murdaugh.
Yeah.
I don't think it's maybe necessary, but at the same time, my main concern is everything taken out of that house that's evidentiary in value? Because the last thing that you want to do is destroy a house that might have key evidence. Look, I think at the end of the day, it's going to be important, I think, more for the families and for the community about what to do that house than necessarily the trial. They have so much evidence other than that house against him.
And Brian,
I just want to make a quick comment on the demolishing of the house. I just think it's such a bad idea. I mean, they can't wait till this trial's over to knock that house down. And I know the Moscow community wants that knockdown, the eyesore, the memories, the this, the that. But how about the power of visiting that house for the jury? The power of feeling that crime scene, of seeing that crime scene from up close and personal. It's not the same thing viewing a photo of it. It's not the same thing viewing a laser recreation of it, or a 3D recreation. Actually being inside that building, I think, is important to the jury. And I really would. Apparently it's been okayed already by the prosecution. I just can't understand that. It doesn't make sense to me.
As we pull up again the video from court today, you were commenting on the way that Kohberger looked in court.
Yeah, I thought it was interesting because last time I saw him in court, he was in the orange jumpsuit. He had on like the big bulletproof vest underneath, which I don't think he did today. I was trying to tell.
Yeah.
I couldn't really see it this time, but he was in a suit. Other cases that I've covered, usually the defendant only wears a suit and dresses up for the trial when the jury's going to be there to sort of, not look like a suspect. So I thought it was interesting that he was wearing this suit today, that was allowed. Also, obviously, there were no shackles, there was no handcuffs. and he sort of just looked like a normal person sitting there.
Yeah, and I was curious about that too, because it is unusual, I think. Just depends on, there must have been a request, right, Jesse?
Yeah, and every state is different, and it's different than like a first appearance where, you know, they're first arrested, they're wearing it, they're shackled up. I think at this point it doesn't appear he's a danger or there's any danger to him, so it might be okay for him to wear.
And his lawyer, by the way, is very concerned about the perception of him. That's come out in court filings, was upset that the camera is always focused on him so that people can analyze his body language. I thought it was interesting today. The judge said something about cameras in the court, said, can we not have the camera always focused on Kohberger?
Yeah.
Which is also something that I thought was sort of unusual.
Even
Can you tell us where to put the camera, you know?
Even cited Lori Vallow-Daybell, the case in Idaho, saying it was too much focus on the defendant there, maybe felt that that case was a case of improper media.
And I'll date myself by saying this, but there was a debate about this in the O.J. Simpson case. There was a lot of talk about where the camera was being focused and a lot of complaints from the particularly defense lawyers about how the camera was moving, et cetera. So that becomes an issue. Anyway, Brian, Jesse.
So interesting, folks. Interesting about on several levels. You know, as I said, that was the first time that I was apprised of the fact that Brian Kohberger had taken an arrest in 2014. Someone in the chat said something about his sister's phone was worth $400. But, you know, sometimes with grand larceny, with the theft of a cell phone, they used to do this, is that if it had the capability, it used to be called what was called an access device. And if it had the capability of charging more than thousands of dollars worth of calls, they would charge the felony. They may have changed that. It used to be also a credit card. Used to, back in the day, maybe I'm dating myself, used to automatically be a felony because of the potential. It's an access device to charge well more than $1,000. So that may be a factor, but that's neither here nor there now. Just the fact that he was arrested. Schmitty, thank you so much for the $5 super sticker. Would the defense take issue with the recovery of evidence from the trash as being improperly handled? Schmitty, you know, there's actually case law on that. And once you throw something out, I think most case law says that you have no expectation of privacy. That's almost like you don't own that property anymore because you're throwing it out. They could argue, oh, but it was still on their property. It wasn't out front where the intention clearly would be for the garbage trucks to pick it up. It was still on their property. Could they argue that? Yeah, but I think, as I said, case law, I think, has said that a private citizen does not have an expectation of privacy regarding their garbage. Therefore, a search warrant is not needed to get evidence that way. So I believe that. I hope I answered your question, but I believe that is case law. Folks, this is Police Off the Cuff, real crime stories. If you like real crime, true crime from a police perspective, and we don't pretend to present it to you any other way. It is from our perspective, from a police perspective, from our experience, from my 27 years on the job, 22 years as a sergeant, 16 years in the detective bureau, lots of years doing plainclothes. That's the perspective we're coming at you from. Phil Grimaldi, same thing, over 20 years, detective. Mike Geary, another co-host, retired NYPD sergeant, law degree, professor of criminal justice. So we give this to you from a police perspective. Does that mean that we somewhat lean toward the prosecution? Yeah, I believe it does, but I think we try to present that in a fair manner. Many people are seeing holes in this case where we don't see it, based on our experience and the case and the evidence in this case. So we're not seeing the conspiracy theories. We're not seeing, look, some of the arguments and I'll bring up one of the arguments that a lot of people are bringing up. There's 2 or 3 other DNA that they've recovered in this house that is unidentified DNA. Does that mean that's the DNA of a suspect? It could. But I want to ask all of you listening right now, if we went into your house and swabbed your furniture and swabbed your countertops, your lamps, your doorway, your doorknobs, would we not lift DNA, unidentified DNA that didn't belong to you? Does that mean that it belongs to a criminal? No, lots of people were in 1122 King Road. It was known as a party house, right? So lots of people were in that location. Does that mean that that DNA that they have, that unidentified DNA, does that mean that that belongs to the perpetrator? No. But will the defense use that to create doubt? Of course they will. Of course they're going to use that to create doubt. Did you check that? I can hear the question already. Officer, did you check the DNA found on the glove recovered on the property? Did you check that to see who that belonged to? Well, it was checked against the CODIS database, and the DNA remains unidentified. I mean, could the defense even say, was investigative genetic genealogy ever used on this glove or on the other DNA they have? So again, for a juror, that could create doubt, couldn't it? That, oh, maybe the DNA, the two DNAs that are unidentified, that could be the perpetrator. But like we've spoken about numerous times, connect the dots. There's more evidence in this case. And we talk about, we're not even privy, and even as the defense, to all the electronic evidence vis-a-vis the cell phone information, where the cell phone pinged, potentially other social media. We don't know about all of this stuff. So for them to say, oh, they got nothing, trust me, I think they have more than nothing on this case. Let me play a little.
As well as a motion to stay or pause proceedings. A spokesperson with the Idaho Judicial Branch says it's not unusual for attorneys to work on this behind closed doors and do this sort of thing. But the prosecution and the defense do disagree about whether or when certain records should be disclosed to the defense. Attorneys were also supposed to take up a third motion to compel discovery. I mentioned they talked about two motions to compel. There is a third, and that has to do with the defense wanting documents related to DNA and the genetic genealogy investigation that the FBI did that led them to Kohberger. But yesterday, the state asked for more time to respond to that ask, and the judge granted it. As for what was brought up in court today, the defense wants training records of officers who did interviews with key witnesses, followed up on tips, collected bits of evidence. But the state says it's out of scope under Idaho rules, and they won't call those officers to testify at trial. They say it's not material to their case. The judge says he'll consider arguments from both sides on this. He'll look at case law and then make a decision. Kohberger's defense attorney, Ann Taylor, is still asking prosecutors for investigative reports and conclusions from all cell phone analysis that was done by the FBI CAST team to find the location of Kohberger's phone. That information, as we've previously reported, was used in the probable cause affidavit to arrest Kohberger and get several search warrants. Taylor also wants reports from the FBI forensic examiner related to the change in the year of the white Hyundai Elantra that they were looking for in their search for the suspect. She said prosecutors told her they'll give her some of that info, but they don't know when. So she asked the court to set a deadline.
Folks, I just want to raise, the defense was looking to find out who in the FBI changed the year of the Hyundai Elantra once they identified the Elantra that Kohberger had as that Hyundai being a 2015. Because if you've been following this case, on the video that they had from the Hyundai Elantra pulling in behind the house, driving around, and of course the famous gas station video, they just had a years that it was between. And at first they said it's between a 2011 and a 2016, but they couldn't pinpoint exactly what year. And then at some point, it was identified once the police officer from Washington State University did a computer check on all white Hyundais owned and driven or registered with the Washington State University as students or working for the university. And he's the one that identified the white Hyundai as belonging to Brian Kohberger. So at that point, did the FBI then say, oh, we're looking for a 2015 once they knew that they had this? So that's the question I think that defense has. Again, they're looking to throw doubt on it and throw perhaps saying to the officer, oh, you're lying then, so that's something that we may want to consider as to why they're doing that.
And as the court is aware, the state has filed its notice of intent to seek death against Mr. Kohberger. These are critical, relevant materials, all of them, including the police training records. They're necessary for us to prepare and present our defense of Mr. Kohberger. They're necessary for us to do our investigation. They're necessary for us to prepare our case and our motion practice moving forward. These are things that we need to have. There is a heightened standard now that the state has filed its notice of intent to seek death, and these are very relevant, critical bits of information. They are discoverable, and we're asking the court to order that they be supplied to us.
So Ms. Taylor's correct. She has everything that the state has in our possession. And we have worked diligently and consistently in getting her all the information that we have in a quick fashion. To date, we have discovered approximately about 13,000 pages of reports, 13,000 photographs, over 10,000 tips, and over 51 terabytes of audio video information.
Yeah, a lot of evidence, the defense saying that they don't believe the prosecution is withholding this information. They believe they are providing it as soon as they can. But the judge did set a July 14th deadline for the federal government to provide all of that information. There might not be hearings on those other issues we talked about, the motion to release the grand jury transcripts and records, as well as that motion to stay proceedings, if attorneys can resolve all of these matters, again, as I mentioned, behind closed doors rather than out in a public courtroom setting, Doug.
And you mentioned also that that is not uncommon to do it that way, correct?
Yeah, that's right. Nate Popino, he's the spokesperson for the Idaho Judicial Branch. I asked him that question. He said it's not necessarily uncommon. Attorneys do this all the time. And it was something that actually going into today's hearing, after I'd reported that I thought it was going to take several hours, was told by some people who are really in the know that they've seen over the last 20 years that happen often in cases like this.
Yep.
So interesting. Why, you might ask, why do they need the training information from the officers? Gordista, thank you for the $9.99 super sticker. Is it unusual for state to withhold law enforcement training? Seems like having an expert's qualification and background training is standard. Gordista, I can only comment on what I know with the NYPD. All detectives on the NYPD, they're required to go to what's called CIC for short, Criminal Investigation course. And that's a 3-week course, classroom at the police academy, where they're taught by attorneys, they're taught by crime scene detectives, they're taught by sergeants, lieutenants, captains, from all different areas of police investigation. Someone there from the Office of the Chief Medical Examiner, for example. We've had Barbara Butcher on, who just put out that great book, What the Dead Know. She was one of the instructors at the CIC course. So yes, that increases the qualifications and the professionalism of a detective. Detectives in the NYPD are also required to take a 2-week homicide investigators course. So again, right there's 5 weeks of, and they're usually impressed with the hours, so a 3-week CIC course would be 120 hours, right? A 2-week homicide course, 80 hours. That's because, even when we go to college, you'll say, oh, for a bachelor's degree, it's 123 credit hours. But as we know, if you go to college, 123 credit hours aren't hours. It's much more time than that. But people are impressed with the hours that you spent in training. Yes, The professionalism of any police department, any investigator is enhanced by the training. And if you can get within your department investigators that are experts in certain things, for example, on the NYPD, if we'd have a child abuse homicide or we'd have a sexual abuse case resulting in a homicide, we would ask special victims to assist us because they are the experts in that business. If we needed someone to interview a child, we would ask for the assistance of the Special Victims Unit because they are experts in that. So thank you so much for bringing that up. That's so true. There's other cases too. NYPD, auto crime. We have an auto crime division. They are experts on vehicles. They can tell you things about cars that the layman or the average investigator does not know. Joint Terrorist Task Force, Gang Division, all of these different units, Highway, all of these different units have their own expertise. Highway, the reason I brought up Highway have accident investigators that are trained in great detail how to investigate motor vehicle accidents resulting in death. Ballistics experts. I mean, that's a science. Ballistics is a science, and when we talk about ballistics, if you ever listen to a ballistic expert, clearly any ballistics expert I've ever met in my life loves guns, absolutely loves guns. When they talk about it, you think they're talking about their long lost love, but that enhances their credibility and their diligence in learning about ballistics, which is, 3 areas of ballistics are internal, external, and terminal ballistics. Internal is everything that happens inside the firearm. External is what happens outside the firearm. And terminal is what happens to a projectile when it hits whatever it hits, either its target, a wall, anything. That's terminal. So you're so correct. And training, don't get me started, but training is so important. Yet, Gordista, again, great. Thank you so much for bringing that up. Training is so important, yet politicians always bring up training. But the first thing to get cut when they need to cut police funds, like you've seen over the past few years, police being defunded, that's the first thing they cut is training. So in essence, you're cutting the professionalism of your department by cutting training. And that's in essence what they're doing. And so again, training is so important. So is that why does this defense attorney want to bring the training up? Because does she know perhaps that these 2 or 3 officers are inexperienced? Could that be? You can make a good defense attorney can make an inexperienced police officer or detective look very foolish on the stand. Because a good investigator, a good detective I shouldn't say good, I should say experienced detective, experienced investigator, testifies all the time. So you think an experienced or a new investigator is immediately good at testifying? No, it's an acquired skill that you only get from testifying and being interviewed and being interrogated, just like a perp. I used to say that when I was a new sergeant, I would have brand new cops. I would say, make as many arrests as you possibly can. Not just because you want to put the bad guy away, but because that teaches you how to get interviewed, how to get interrogated, how to be on the spot, how to remember how to tell the truth, how to take good notes when you're out in the field so that you can refer to your notes when you're going to be grilled, whether it's by your boss, which is, in the police department, there's always, when you're interviewed or confronted by a boss, it's always said from the very beginning in the police academy, always have a story. Even if the story isn't plausible to tell your boss, have a story. Because if you stand there like a blithering idiot and can't explain your actions, that's when you're going to have a problem. I don't mean perjure yourself or make something up, but have a story to tell your boss. Let him know what your thought process was. Let him know why you did a certain thing. So as long as you have a story and it plausible, it makes sense, that's good. That's going to help you. And as far as testifying, professionalism. I can't stress professionalism enough. Taking good notes, dressing nicely. You don't go to court looking like a slub. You have a clean pressed suit. Or if you're in uniform, you have your uniform looking sharp, washed, pressed, wearing all your medals, which juries always love that, you know. So all of those things are part of professionalism. Now, does Ann Moore want to interview these 3 officers and know all about their training because she wants to create doubt, right? If they interviewed some important witnesses, she's going to be all over them. I remember I was on the stand once and this legal aid attorney asked me a question about my disciplinary history. Said, Sergeant, I'd like to know, what is your disciplinary history? She wanted to hear that I was in trouble a million times and that I'd had command disciplines, charges, and specifications and all of those things. And I looked at her and I said, I don't have a disciplinary record. And the first rule with attorneys is never ask a question unless you know the answer to it. She could have subpoenaed my disciplinary record, but instead she chose to roll the dice and figured, oh, he's active, he's out there, he must have a disciplinary history. And when I said I didn't have a disciplinary history, she didn't know where to go after that. It more or less ended her questioning. So we talk about the death penalty on this case, and it changes the sort of the scope of the case. Now, what do I mean by that? Well, I think it definitely gives the prosecution more leverage as to who they're going to choose as jurors. You can't be a juror on a death penalty case. From what I understand, I've never actually testified at a death penalty case unless you are pro death penalty. So what does that do to the makeup of the jury? I think it makes the jury inclined to be more pro law enforcement. So it also, as we spoke about before, it gives leverage to the prosecution. The prosecution can, at some point, approach the defense and say, look, this is what we got. He's done. He's toast. And we're going for the death penalty. Take a plea and we'll give him life without parole. That's the offer. Life without parole. Life without parole on each count. They may say that. So, because we've seen in the last few years, we've seen people who were sentenced to life without parole get paroled, and very disheartening. So here we go. I want to play a little bit of this. Mr. Gonsalves, who is absolutely 100% for the death penalty.
This morning, in an NBC News exclusive, the father of victim Kaylee Gonsalves reacting to news that prosecutors plan to seek the death penalty against Brian Kohberger, the man accused of murdering his daughter and 3 other students at the University of Idaho.
It's a relief. I'm glad that we're in a situation of strength and the evidence is there. And we feel that we can, they can go forward with this.
The family's attorney believes it's a clear-cut death penalty case.
If you're not going to pursue the guy for a death penalty on a case like this, who are you going to pursue for a death penalty?
In just a few hours, Kohberger is set to return to a Moscow, Idaho courtroom for another pretrial hearing. His legal team is requesting records from last month's grand jury indictment of their client and are asking the judge to pause legal proceedings until they receive those materials. Already a key part of the case for both sides, Kohberger's DNA and where it was and wasn't found. While prosecutors said in a court filing earlier this month that Kohberger's DNA is a statistical match to DNA found on a knife sheath at the scene of the murders, his lawyers say authorities did not find any victim DNA in his apartment, office, home, or vehicle.
Is this your car?
He's had over a month before those search warrants were executed after the crime to throw away his clothes, wash his car, clean out his apartment. There's multiple ways to explain the lack of DNA in his vehicle, in his apartment. There's not a lot of ways to explain his DNA on the sheath of the murder weapon.
The legal battle is also unfolding just over a mile from the scene of the quadruple homicides. The off-campus home where Madison Mogen, Kaylee Gonsalves, Xana Kernodle, and Ethan Chapin were killed was set to be demolished before a judge ruled it should be preserved. Now the University of Idaho says they hope to have the house down ahead of the new school year. The Gonsalves family says the house should be preserved through trial.
I don't want to sit 6 months from now and hear somebody in the court case say, well, I really wish we could be in the house right now.
Once the case is over, then they can move on. But right now, it's the crime scene.
Brian, Kohberger has not entered a plea. A not guilty plea has been entered by the judge on his behalf. And regarding the death penalty, there's a new law here in Idaho allowing for death by firing squad if they can't locate the chemicals necessary for lethal injection. That law goes into effect July 1st. Savannah? All right.
You know, folks, can you imagine that? Can you imagine, I think, the pushback that, say, we'll move months ahead, maybe a year ahead, that Brian Kohberger is convicted in this case. Could you imagine that the death penalty is a firing squad? Could you imagine the pushback that that's going to receive from the public? I think it will receive a lot of pushback from the anti-death penalty people. But it does sound barbaric, a death by firing squad. It sounds a little bit from another era.
Aaron, thank you. I want to turn now to NBC News legal analyst Danny Savalas. Hi, Danny. Good morning.
Good morning. So the prosecution is saying they're seeking the death penalty. So you wonder if that makes us think that they are very confident with their case. What do you think?
Well, statistically, one study shows that Idaho prosecutors seek the death penalty in about 20% of death penalty eligible cases. Yeah. They only get death penalties in about 3% of those that go to trial. So Idaho prosecutors, it seems, are willing to try for the death penalty. They'll file the notice. That may be a negotiating tactic, of course. If they file the notice of intent, then the defense says, uh-oh, the stakes are higher. Perhaps that's meant to bring them to the table. But it seems that under Idaho law, the death penalty, which the Supreme Court has very much restricted, they're a little more permissive maybe than other jurisdictions.
How does it affect the case? Let's say this remains a death penalty case and it goes to trial as a capital case. How does that affect in terms of the jury that is selected and the evidence that's presented?
Absolutely. So in these cases, it becomes really two trials. You have a trial on the guilt phase, and then you have a trial on the penalty phase. Yeah. And as they must in every state, they have to take into account the aggravating factors and the mitigating factors. And in Idaho has a list of aggravating factors. If the jury finds during the penalty phase that any one of them was met, and I'll give you an example of one, that during the crime, the killer committed another murder. That is exactly within here. And there are other aggravating factors that fit as well, but I'm just giving you one example. If the jury finds that beyond a reasonable doubt, then the defense has to come up with some mitigating factors, or else the jury must essentially impose the death penalty. So Idaho procedure creates a clear path to the death penalty with those aggravating circumstances, one of which, an example I gave you, if we get to that phase, it's not likely he'd be found guilty of one murder and not the other. So it might be a foregone conclusion once you get there.
That's a pretty strict statute in Idaho, it sounds like.
Permissive for the death penalty, although the Supreme Court has limitations it imposes when compared to other states. It could be said that Idaho is more death friendly.
We keep hearing about this DNA information. How likely would the court grant the defense access to what they want, like the DNA information?
This is interesting, and and I'm colored by the fact that I am a defense attorney, but the state's argument is essentially that there are two kinds of DNA. There's what we're familiar with traditionally, which is STR. This is going back to the OJ case. This is traditional DNA evidence. The state says that they use this new kind, this emerging evidence, IgG or forensic genealogy evidence. They use that to build a genealogical tree. But they're saying we use that as kind of a tip, as a lead. We're not going to introduce any of that at trial, Judge. So therefore, we don't have to turn that over to the defense under the rules. And the defense is saying, look, the rules call for anything that is a scientific report to be turned over. This also is something that is going to be very compelling information. It could exonerate our client. We should get it. The state probably has a more technical, rule-based argument, and the defense has a more spiritual argument that, look, this is something the state used. We should get to see it.
All right, Danny.
He spoke very well about that. You know, it's very interesting because investigative genetic genealogy is a relatively new science, and I don't know if the law, and by the law I mean the criminal procedure law, has necessarily caught up with the science. Therefore, I don't know if there's a great deal of procedures written about genetic genealogy, and I mean, you know, procedures that the police follow. Like, how do you do this? How do you do that? How do you build this tree? Now, in this instance, he mentioned STR, which is the way they collect criminal DNA, which stands for short tandem repeats. And in genetic genealogy, they use something called SNPs, SNP, single nucleotide polymorphisms. And the difference is in STR, short tandem repeats, there's like 20 markers. In SNP, SNPs, single nucleotide polymorphisms, there's over 1 million markers. And if you listen to probably the number one expert in the nation, CC Moore, she says that investigative genetic genealogy should never be used to develop probable cause. It just should be used as a lead, almost like as a tip. And from there, a great deal of investigation must be conducted. Folks, if you're looking for a great defense attorney in the New York metropolitan area, then Joe Murray is your man. Joe Murray is a retired member of the service, a retired police officer, 15-year veteran. And you can reach Joe on his cell phone at 718-514-3855 or email him at joe@jmurray-law.com. or go on his website, jmurray-law.com. Joe Murray is not only a great defense attorney, but a huge, huge supporter of the Police Off the Cuff podcast. So, folks, you know, this case is very interesting. And a lot of, you know, I believe a lot of defense attorneys and as well as prosecutors, everyone's still learning about this investigative genetic genealogy, even though it's solved huge serial killer cases. And we're seeing that this case now in Boston of this serial rapist who's a New York attorney, they're coming up with more and more cases on this guy as we speak. So the science of it is just an incredible thing, you know. And you know, one of the things that we learn about in this case also is many people are saying, oh, the prosecution doesn't have anything. You know, trust me, they would have not come out with seeking the death penalty unless they're pretty sure that they got a pretty damn solid case. All right. I think that's an indicator that they're pretty confident that they can get a conviction in this case. Again, we mentioned earlier on the show, will they offer him a plea? Will they offer him a plea of life without parole? Is that a possibility? And that's the kind of leverage you have when you go from the death. You go for the death penalty, and at some point, maybe at the start of the trial, they may approach the defense and say, "Look, here's the deal: have him plead guilty to all counts, and we'll spare his life, or else we're going." They already announced they're going for the death penalty, and in Idaho, a firing squad. So it's crazy. But it does give the leverage. It gives leverage to the prosecution, not to the defense. So it's out there, and that's what's going on in this case right now. I've played this video a number of times, and this is a prosecutor from California who was a homicide prosecutor, I believe, for 17 years. His name is Matt Murphy, and he was on News Nation. And I'm just play a little bit of this. He said that the evidence in this case is overwhelming. So are we going to believe content creators and people spreading rumors on YouTube? Or are we going to believe this? And again, it's not that, something you can believe whatever you want to believe. The only people that are important in this case are the potential jurors that are going to sit in that box and decide the fate of Brian Kohberger. Anyone out there, myself included, you have your right to your opinion, whether it's an educated opinion or whether it's just you're just throwing mud at the screen. You have a right to your opinion. Let me just play a little bit of this, and we'll see what Matt Murphy has to say here.
So overwhelmingly awful, for lack of a better term. I think there's going to be a lot of pressure within the DA's office to actually seek the death penalty on that.
And the evidence seems to be very strong. I mean, it's not circumstantial. There's DNA evidence, there's cell phone evidence, there's a lot of evidence here.
The evidence against Brian Kohberger is overwhelming, and that actually is a factor.
Boom. I mean, here's a prosecutor saying the evidence is overwhelming. All right. So again, when I hear people saying, oh, the prosecution has nothing, I'm like, okay, what law school did you attend?
In that decision. Essentially, when people weigh the death penalty, elected DAs, they look for two things. They look for overwhelming evidence, absolutely no doubt of guilt, because the jury will be allowed to consider that in the penalty phase. And remember, this is a bifurcated system. So first there's the guilt trial, and then there's the penalty trial. They are allowed to consider what's called lingering doubt. So if you have a case where there's some wiggle room or a juror might not be sure, they're allowed to consider that in imposing the death penalty. The second thing that every elected DA will consider in making a decision like this is the shocking nature of the crimes. The vast majority of cases that are eligible for the death penalty in the United States, the elected DAs don't actually seek it. In Orange County, we sought it in less than 4%. So it is.
Wow. Why so seldom?
Well, for one thing, you want to be absolutely sure as a prosecutor because you have to take the death penalty very seriously, even in a state like California where it's essentially symbolic. It's a big deal to do it. It's also a lot more work and it takes a lot longer. And then it faces much harsher appellate scrutiny once the conviction and the sentence is imposed.
It also affects how you pick a jury.
It absolutely does. Now, what's interesting about this is that you're entitled to what's called a death qualified jury. So they'll bring in the veneer or the jurors for the trial, and they'll all fill out questionnaires, and they will be asked about their views on the death penalty. And if they cannot follow Idaho law, which allows for the death penalty, they will be excluded for what's known as cause. So they won't actually be in the jury panel, or they shouldn't be.
So you've been in this position before as a prosecutor, a homicide prosecutor. What do you think he's going to do?
I think this one is pretty clear. My guess is he's seeking the death penalty. Now, behind the scenes, what's happening is he's probably meeting with the defense and saying, show me what you got to try to talk me out of it. In California, we call that a livesy hearing. In Idaho, I don't know what they call it, but I'm sure they're going through that process right now.
Thank you for watching. Go to newsnationnow.com to find News Nation on your television provider. And don't forget to click the
Sorry, folks, I wasn't quick enough to the drawer to stop that little News Nation commercial. So, folks, that's my show for today. It's a little matinee. I want to thank everyone for tuning in today. Look, this is one hell of an interesting case. There's a lot of issues in this case. There's a lot of people that think one way, a lot of people that think the other way. Very few people have no opinion whatsoever. But we'll see as the case moves forward. There's so many different issues, as there is in just about every case like this. I also want to just say at this point, I want to always mention the victims, Ethan Chapin, Zena Canonal, Madison Mogan, and Kaylee Gonsalves, and prayers to their souls and to their family members for the insurmountable loss they had in losing these amazing human beings, and that we can never lose sight of that. That also always has to be on our mind. That doesn't mean that Brian Kohberger does not get a fair trial. It does not mean that he's not innocent till proven guilty. But I think we always have to remember the subject of this case. And it was those 4 people that I just mentioned. Folks, have a great day. Police Off the Cuff, Real Crime Stories. Thank you so much for tuning in. I'll see you next time.
One episode just ain't enough.